Okay, hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the single justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. The first case is 2022 J0118 V&J LLC versus Deirdre A. Dundon.
Thank you. And so again, good morning to you both. Ms. Dundon, you're here pursuant to the issue of whether or not your bond should have been waived. And you assert that Section 261, Section 27A through D mandates a finding that your bond is waived, and that the court's analysis with respect to Section 239, Section 5 was the wrong chapter on which you rely. Is that correct?
Yes, Your Honor.
Okay, I'll hear you.
Okay. May it please the court. Good morning, Your Honor.
Good morning.
We've established, my name is Deirdre Dundon. I am the appellant defendant appearing pro se in this matter. And please bear with me, Your Honor, because I get anxiety, so I'm very nervous.
That's okay. You take your time.
Okay, because I've written something up. It just helps me keep my train of thought.
Okay.
Okay, so I am here seeking relief from the requirement to pay an appeal bond and use and occupancy under Mass General Law, Chapter 261, Section 27A through G, also known as the Indigent Court Cost Law. I'm here to ask this honorable court to either waive, substitute, or order government payment for the appeal bond and use and occupancy costs under the statute so that I may receive equal protection under the law, as would a party who is not indigent and able to pay these costs.
Okay. And right now the bond is set at $1,700, is that right?
Yes, Your Honor.
As well as the use and occupancy payments?
Yes, Your Honor.
And that $1,700 reflects the amount that you're charged for rent, is that correct?
No, Your Honor, I actually go into that later.
Okay, what's your rent right now?
It's no rent. There's no rental relationship. The plaintiff.
Oh, you're the former owner. You're the former owner of the property.
Yes,
okay,
Your
go
Honor.
ahead. Go ahead. Let me let you continue.
Okay, thank you. Mass General Law, Chapter 261, Section 27C, subsection 4 states, and I quote, if a court makes a finding of indigency, it shall not deny any request with respect to normal fees and costs. And it shall not deny any request with respect to extra fees and costs if it finds the document, service, or object is reasonably necessary to assure that assure the applicant as effective a prosecution, defense, or appeal as he would have if he were financially able to pay. Excuse me, I'm very dry. This is okay.
Take your time. I don't know. We lost Attorney Raffleson.
Do you need me to wait?
Nope.
No,
back.
Judge, I'm here. Sorry, I'm
Okay.
in the Westfield District Court, and I'm on my phone right now.
Okay, hang in there with us.
Okay. In this instance, the bond and use and occupancy are court-imposed fees that must be paid, otherwise my appeal may be dismissed. Thus, they are necessary to my ability to appeal, and under the statute, I should be afforded the same opportunity and due process rights as someone who are financially able to pay. To be clear, there has never been a rental relationship between the parties. There was never an obligation to pay rent or use and occupancy to the plaintiff. This was an extra cost ordered by the Worcester Housing Court on March 3rd, 2022, after a hearing on my motion to waive the bond. I filed the waiver request under the indigency statute, but was not given an opportunity to explain. The Honorable Judge Horan of the Worcester Housing Court allowed the plaintiff's motion to set the bond and use and occupancy despite my explaining that I had not been properly served with the plaintiff's motion. As I explained to Judge Horan, I did not consent to email a service and had previously requested that the plaintiff send time-sensitive documents via overnight or priority to ensure that I receive them. As of this date, I still never received the plaintiff's motion to set the bond in the mail, although I did eventually find the email in my spam folder. So I was not able to properly address the plaintiff's motion, and it should not have been considered at the hearing. Nonetheless, that is where the amount of $1,700 came in, despite my testimony regarding my income, which was not enough to even cover half of the $1,700. My right to access the court is a constitutional due process right where my property rights are at issue. Under Chapter 261, Section 27C, I need not prove a non-frivolous appeal, but show that affording an appeal cost is an object that is reasonably necessary to assure the applicant as effective an appeal as I would have if I were financially able to pay.
So it's your position that we need not even address whether or not you had non-frivolous defenses. Is that what I hear you say?
Yes, Your Honor.
You rely strictly on the indigency statute.
Yes, Your Honor.
Okay, go ahead.
Chapter 261, Section 27D also says that in any case where the court denies a request for waiver, substitution, or payment by the Commonwealth of fees and costs pursuant to Section 27C or any other provision of the law, which is the 239, Section 5, that it was ruled under, the applicant may take appeal as hereafter provided. Once one is proven that they are indigent, and the court did find that I was indigent, there is a statutorily mandated procedure. And it holds that if it is a normal court fee, then the court must waive it without a hearing. Or if it is an extra fee, then the court must waive it if it is an object necessary to an indigent litigant to equally prosecute their case as somebody who is not indigent. And my point about the frivolousness is that somebody who could afford to pay, they would not look at it whether they had a frivolous appeal.
Well, it depends on what statute we're looking at, but go ahead.
Okay. As this cost of use and occupancy and the appeal bond did not exist prior to my motion to waive the bond, it is clearly a court-imposed fee or cost. If the court sees fit to lower the amount of use and occupancy, as there is no mortgage here, and the only carrying cost by the plaintiff are taxes and water and sewer. The plaintiff claimed at a previous motion hearing, that they did not have insurance on the property, then I would still ask this court to adhere to the indigency statute and waive, substitute, or require payment by the Commonwealth. I ask that this honorable court keep in mind that my equal protection and due process rights are at stake, and I pray that the court grants me relief I am seeking. And if you have any questions for me, I'd be happy to answer them.
Well, thank you kindly, Ms. Dundon. I don't have any additional questions for you. Is there anything else that you'd like to say?
Just to reiterate that without any of these remedies, I won't be able to prosecute my appeal, and I just ask that the court keeps my equal protection rights in mind.
I understand. Thank you kindly. Let's hear from Attorney Raffleson.
Thank you, Your Honor. May I proceed, Your Honor?
Please do. Why don't you pick up where she left off with
Thank you,
respect
Judge.
to the impact that she says with respect to 239, Section 5, if I were to adopt her theory of the case.
Judge, just some basic quick facts. I'm sure you are familiar with them, but this is a post-foreclosure eviction. Ms. Dundon is the former owner, and my client, the manager of B&J LLC, is a real estate agent who provided an affidavit to the court stating that she believed that the fair market value was anywhere between $3,000 and $3,400 for this 2-unit house. The judge, giving Ms. Dundon a bit of a break, stated that $1,700 would be fair because Ms. Dundon was occupying only one of the 2 units at the house. So she set $1,700 as the bond and $1,700 for use and occupancy payments going forward. To address the issue of lack of service, Judge, Ms. Dundon at one point had told me that she had had problems getting mail at her address. We have sent all correspondence by mail to her address and sent it by email as well to cover our bases. So we did effectuate service on Ms. Dundon. Judge, my argument primarily in response to Ms. Dundon's is in relation to the recently decided Alton King case, Bank of New York Mellon versus Alton King, which holds that a former owner may be responsible for making use and occupancy payments. And that's the case here. Ms. Dundon was required by the court in her to continue with her appeal to make these payments, and she has appealed them to this court. However, we believe that they were properly made. The amount was properly set by Judge Horan. Furthermore, Judge, this appeal is frivolous insofar as this case was already decided. The bank, previous owner of the bank, had filed a post-foreclosure eviction against Ms. Dundon, which went to appeal.
I understand there were already 2 summary judgment orders entered in this matter.
Correct. So there are 2 summary judgment orders. And at this point, the case has already been decided under res judicata. And this is an entirely frivolous appeal. My client has had to eat tens of thousands of dollars litigating this case, and all the months that have gone by, and all the expenses. And for those reasons, Judge, we would be asking that you uphold the amount set by the judge.
Attorney Alpherson, I think I got it. Anything additionally from your perspective?
No, Your Honor.
Thank you both. The matter stands submitted.
Thank you, Judge.
Thank you.
Okay, hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the single justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. The case is 2022 J125 Brookline Barclay House LLC versus Peter Rapoli.
Thank you. So as I indicated, Mr. Rapoli, you get to go first. I believe you're challenging some use and occupancy payments that have been imposed. And I'm happy to hear you, sir.
Yeah, I according to counsel, the housing court judge agreed that I had a non-frivolous basis for the appeal, and as far as I know, if it is reduced, if the money reduced that I think Mr. Krems is talking about to what you can afford, there will not be deprived of your non-frivolous appeal. And I guess according to statute, according to this briefing, it should be reduced to an amount that I can afford, which you will need to tell the single justice how much that is.
Well, as I understand it, you were paying rent, right?
Yes.
Okay.
Recently, no.
Hold on, Mr. Rapoli. At the same time that you were paying rent, you were also being charged rental for the garage. Did a garage come with the unit?
Yes.
Okay. And as I understand it, the rental payment was $3,350 per month. Is that right?
300, something in that neighborhood. Yes, you're right. I thought I had 3625 here on my sheet.
That includes the 225 for the garage?
It must. Yeah, I would say yes.
Okay. And so go ahead. I'm listening.
According to this form, according to my counsel, that the plaintiff has no basis to move to dismiss any appeal and for issuance of execution. Having timely requested review of the bond order within his rights.
Okay, so here we are. I'm listening to your challenge to the bond order. The bond was waived, as I understand it.
Correct.
Okay. So you had a hearing, right? And at the conclusion of the hearing, I believe you were ordered to pay $3,400, which is actually $50 more than what the rent was, plus the $225. That's probably how you get at your 36 and a quarter number.
Correct. Yeah, I'm looking
Okay.
at trying to find that by myself. Yeah.
Now, let me just ask you a couple other questions. So
Sure.
you had fallen behind at the time of the pandemic. It looks to me, when I looked at some ledgers, that you had been pretty current with your payments up until that point or thereabouts.
Correct.
Um,
Yes.
And then you got some assistance. I think you got some public funds that paid about $60,000 worth of the rental monies that you had in arrears. Is that correct?
Correct.
And that left $7,000 still outstanding, as I understand it, or thereabouts. Is that fair to say?
I believe that's correct.
Okay. But then the proceedings continued, and I'll have some questions for Attorney Clems about that. And that's what brings us to where we are today. After the possession was given to the Brookline Barclay House. Is that correct? You have a
No,
pending
I don't.
appeal. You have a pending appeal right now.
Yes, we do. That's correct. That was yesterday. Yeah.
Okay. All right,
Yeah.
so you pick it up from there. Go ahead.
Well, I don't know why we're here, honestly, Your Honor. This is on Attorney Krem's yesterday, and I'm not sure what's going on, to tell you the truth.
Well, I'm here to hear your challenge. I believe this is your appeal of the use and occupancy payments.
Right, and basically, I also was judged indigent, which is why that kind of money for rental is impossible at this point.
Well, what do you think you can pay?
I'm getting Social Security $457 a month, and if I put in what I owe every month for food, gas, electric, God, $17, I assume.
Excuse me?
Exactly, $17.
You think that the use and
That's what I can
occupancy
afford.
You think the use and occupancy payment should be $17 a month?
That's what I can afford, if that's what you're asking.
That's what I'm asking, what you think you should pay.
Are you talking to me? Sorry.
I was. You answered my question directly. Thank you.
Okay.
What else would you like to tell me, Mr. Rapoli, if anything?
Well, if I think that's the purpose of this meeting, I believe, is to discuss what we just discussed. And I'm not sure I have anything more to ask unless you have a question for me.
I don't. This is a hearing, not really a meeting, but I understand. I don't think I have any other questions for you. I just want to make sure you've had a full opportunity to make your case and tell me anything that you wanted me to know.
Okay. The other thing, I do have one other thing that I remember from past hearings. There was a problem with the RAFT money, actually ERAP money, that was supposed to come in, and my agent at the time, I don't know if this is appropriate now to bring this up or if it's even relevant, but I was told you don't pay rent until that money comes in, and still hasn't been resolved. And that's the only thing I think I can add.
Okay. Let me hear from Attorney Krantz.
All right.
Thank you, Your Honor. We are asking that the court endorse the order of the trial judge that the fair rental value of the premises is $3,400 a month, and with a parking fee of $225 a month, that as a condition of maintaining his appeal, he pay $3,625 commencing immediately and beginning at the first of each month going forward. We had
So your position is that it should be calculated by fair market value, not by the rent contract.
That's correct. That's correct. The fair rental value, as Rachel Reynolds, the property manager for 16 years, the senior property manager, as she testified at the trial, and as the judge stated in his appeal bond order, he said, quote, he said, Rachel Reynolds, the property manager for the past 16 years, testified that 2-bedroom, 2-bath units, such as the premises, are currently being rented for $3,400 per month. And the defendant is further obligated to pay a parking fee of $225. So we think we should go by the fair market value of the property. At a minimum.
And what do you rely on for that? King?
We rely on the testimony of Rachel Reynolds at the trial.
No, not on the figure, but on whether it should be fair market value versus rent contract.
Well, I think in Davis versus Comerford, they were talking about what is the fair rental value of the property. So
fair rental value. Okay.
Yes. But if the court were to decide that it should be the amount of the lease, that's only $50 less. So that would be all right also. I think it should be the fair rental value, the fair market value, what they would be renting it for today per Davis versus Comerford. But if the court again decides that it should be the amount per the lease, then that's fine too. It would either be $36.25 or it would be $35.75. So either one would be fine with us. I do want to point out that Mr. Rapoli currently owes just in rent $17,046.73.
I'm going to have another question for Mr. Rapoli in a moment. A little bit unusual that we'll go back and forth here, but I have another question for Mr. Rapoli. But before I ask him that, let me ask you, Attorney Krem.
Yeah.
So you accepted $60,000, correct? He got some rental assistance, is that correct?
That's correct. That's correct.
All right.
$59,000.
And when you get the $60,000, it seems odd to me that you're able to get the funding source for the $60,000 and then continue with the eviction process. It seems to me that the funding source is to be able so that the tenant can stay in the house. Is that not the spirit behind it?
The funding source was to reimburse the landlord for the rent. He does live in a luxury building in Brookline, and the rent is significant.
I understand. Isn't the spirit behind it to allow the tenant to be able to remain in the unit?
And we did allow the tenant to remain in the unit, but that doesn't mean that once he gets money from the RAF program that he can live indefinitely and pay nothing going forward.
Okay. Let me ask you this question. When you, did you have to submit some paperwork to, I think it was Boston Metro, was that the name of the agency?
We did. I think it was, I believe this was through Metro Housing Boston. Yes, Your Honor.
And is there an application that your client had to fill out?
There is.
I didn't see that in the record. Is that in the record?
No, it's not. But there was nothing in there. There was nothing in there that the landlord agreed to or signed that said that if we accepted the money, we would never evict him or that we would allow him to stay and pay no rent going forward indefinitely. There was nothing in there like that. It basically just said that, and if he had, in addition, Your Honor, if the amount that we received had gotten his balance down to zero, that would have been different, I believe, or it might have been different. If it had got down to zero, okay, then I think our case would have been over and we would have had to dismiss our case. And I don't think there's any question about that. However, the amount that we got still left him a balance of around $7,000. So it never got to zero. So we were not obligated to dismiss the case. And therefore the case, we were allowed to continue. So that's a big difference in this, Your Honor.
I understand.
I do agree if it got.
Can you provide that document to the court?
I can, yes, I can, I may have it in my file, but sure, I can get it to the court, hopefully this afternoon. I'll look in my file. If I don't have it, we can get it from, I can get it from my client.
Thank you.
Yeah,
All right, go ahead, Attorney Krim. I'm sorry to interrupt.
yeah, no problem. So what we're here to discuss is the fair rental value of the premises. And the lease says that it is $33.50 plus the $225, which is $35.75. Rachel Reynolds, the manager, testified that because since the lease is a couple of years old, that the current rental value is $50 higher. So the total is $36.25. I'm quoting again from the trial judge in his appeal bond order. He stated, defendant did not contest the testimony of Ms. Reynolds on the current fair market value without defects or the parking. Defendant stated there were issues with the heat, but did not provide any credible evidence that this condition presently exists. The court does not credit his testimony on the heat, and he alleged no other defects. The court finds no credible evidence of conditions affecting habitability. So the trial judge, after we had two lengthy hearings, one at the initial trial and then on the bond, concluded that there was no credible evidence of conditions affecting habitability. Now, in Davis versus Comerford, there were counterclaims, there were legitimate issues about whether there were defects, and the court didn't really consider those. This judge, Judge Kelleher, spent a good bit of time at two separate hearings considering habitability, whether the apartment was in good condition or not. And his conclusion was that there was no credible evidence that there are any conditions affecting habitability, and that we should take the fair rental value. In addition, the judge noted in his amended findings that the defendant's answer didn't say anything about any defects or any problems at the property, that at the trial, all the defendant talked about was some construction, some jackhammering that was occurring in 2020. And talking about that had, whether or not that occurred, and again, and the court didn't even find that to be credible, that testimony by the defendant. But even if it was credible, that's 2020, and that has nothing to do with what the fair rental value of the property is today and going forward.
I understand. That's the singular question that I'm going to ask Mr. Rapoli as soon as you're done, but go ahead.
Right, okay. And then, and the court said in its decision in the amended findings that they did not credit the defendant's testimony about any alleged deficient conditions or that it affected his quiet enjoyment or use of the premises. And at the trial on December 15, 2021, Mr. Rapoli never mentioned any issues about heat. He only mentioned some jackhammering in 2020, didn't talk about heat. Then at the appeal bond hearing, he talked about heat, and the court again did not find that credible. And Ms. Reynolds also testified at the trial that to her knowledge, Mr. Rapoli had never complained about conditions at the premises, that he never stated he was withholding rent. He never said anything about spending money to fix conditions, that there have not been any significant work orders at the premises, that the Board of Health has never come to the premises, and that any jackhammering, which he was talking about, occurred in 2020, not in 2021 or 2022. So the credible evidence at the trial, which the judge stated many different times, both orally and in his different decisions, is that the apartment is in good condition. There are no defects. There are no problems with it. There's nothing affecting use, the use and enjoyment of the premises. And therefore, the judge considered all the factors, very carefully considered the factors in Davis versus Comerford. So the judge's decision should be affirmed, and the amount that Mr. Rapoli should have to pay should either be $35.75 or $36.25.
Attorney Crum, thank you very much. I think I understand the position. Mr. Rapoli, one more question for you, sir.
Yes.
The construction that was going on, that's all done?
Yes, all the HVAC units are in.
and the construction is complete.
Yes, they don't work, but they're complete.
Okay. I think
Terrible.
I think,
They're awful.
I think we'll
I
leave it
got
at that.
6 layers on right now. Can I add things to what Mr. Krem said? Because they were never brought up. They were brought up at the trial on December 15th. And this isn't a luxury building, by the way. Basically, I made a lot of statements about quality of life. We went through 6 months of jackhammering pretty much next door to us. It was terrible. In fact, I even have a CD of it. Ms. Reynolds misspoke the truth under oath that I never complained. I have proof of that. None of this was considered by the judge. I wanted recoupment for all the construction I put up, the tents I put up of plastic to keep the dust down because it was a major problem. In fact, everybody complained about it. I'm not sure what Attorney Krems is actually talking about. Either it's misrepresented by Ms. Reynolds or he's blocking his ears, because I mentioned all this at the trial, which I didn't know was a trial, honestly, until the day of the trial. I talked to legal aid in the hallway. They said, throw everything you got, whatever you got. This is a trial. We can't go back on this. And I did. And it was not considered. It wasn't the heat. It's the electric that's the problem. Our electric went up 700%, and I have proof of that. I had it that day. All of this stuff was on the docket, and it was not considered by Judge Kelleher. And I'm sorry if you think it was Mr.
Don't
Krems,
speak.
but it wasn't.
Listen, Mr. Rapoli.
Okay, Judge, yes, go ahead.
Don't speak to Attorney Krems. Direct your comments and your argument to the court.
Okay. I made a statement on the following hearing that we had, and I brought up all of these efforts again to reiterate what I had said in the trial. And basically, I want recompense for the 6 months that we had to sit here and listen to this junk every day. And I think Barclay House didn't know what they were in for. They
All right.
hired these people to come in.
Listen, I'm going to interrupt you, Mr. Rapoli, because I want you to confine your arguments to what you think is the fair amount that you should pay by way of use and occupancy. And as I understand it, it's $17 per month.
Yeah, unfortunately, it's funny, but yes, that's true. That's all. There's no money here, Your Honor.
Okay. I thank you both. The matter stands submitted.
Thank you, Your Honor.
And thank you, Your Honor. And what's the protocol now? When is your decision to be made?
It'll be made timely.
Thank you.